members of the media and the wider population. This afternoon, I would like to just clear up an editorial that appeared in one of the daily newspapers yesterday, where an allegation was made to the Ministry of Works and Transport about the readiness for the demerit point system. And I thought that editorial was a bit unfair, and this afternoon I'd just really like to clear up the issues surrounding the delay in the proclamation of the U-turn system. This project have been in the making for maybe over 20 years. This government and this cabinet took the decision that it is about time we continue the improvement in the Road Traffic Act, which results in the saving of lives on our roadway. And we set about to implement this new system, which is the demerit point system, the red light camera enforcement system, and the whole upgrade of the Road Traffic Act. On the 22nd of January, we had a launch at the Hyatt. This was done after a significant amount of consultations with all the stakeholders, both in Trinidad and in Tobago. This was a work in progress over the last 2 years. And we are at a point where we are about to commence this new system in Trinidad and Tobago. At the launch on the 22nd, we indicated that we would go live on the 2nd of March. There was a campaign that had started before the launch. It was ramped up from the launch. What we saw happening is that a significant move by the population to upgrade their information, have their vehicles inspected, upgrade their driver's permits. A lot of transactions started to take place at the license office. The ministry took a decision to delay the proclamation of the law, because here we are in a situation where we're going to bring in this new system which will transform the way we use our roadways. But you have a buy-in from the population who welcome the system and were making a genuine attempt to upgrade their information. This was already debated in the Parliament. Unfortunately, and I say unfortunately because I did get a call from a member of the media from that newspaper, and I clarified that to them because they were of the impression that this was not debated in the Parliament and things like that, and that is why the law wasn't proclaimed, which was wrong. I did indicate that it had already been debated in the Parliament, and the minister had the right and the ministry to delay the proclamation until we were ready, and we feel the population was ready to have it rolled out. Unfortunately, I still saw that editorial, which, did not really reflect what was happening. So I just want to put the records straight. We are ready with the system. What we're trying to do is to allow the population to continue to come in, upgrade their information. If you would see the officers on the 2nd of March, as we had promised, at the ministry, we did distribute all the units that will be used by the officers, over 300. The officers have in their possession, the software platform have already been commissioned. The proclamation will be done by the Attorney General on the request now of the Minister and the Ministry of Works. And there's a simple reason for that. Once we do that proclamation, the old law ceases and the new demerit point starts. We thought we would use this extra month because of the response from the population to continue the education program, allow them to come in and upgrade their driver's permit, their vehicles, and you'll be surprised. The units are out there, and we have already started to pick up stolen vehicles, and people have been charged. Within half an hour, of using these devices, we were able to pick up stolen vehicles on the road. This system is not a revenue-generating system for the government. This is something about road safety and about how we continue to reduce the carnage on our roads. Again, I want to say that the system at the ministry, we are ready, but the reason for the delay in the proclamation is because of the success that we are seeing and the comfort that we are getting, where the citizens are actually coming into license office. We have actually had to beef up the staff at the license office to keep up with the amount of transactions that is taking place. So I just want to debunk that editorial, which tried to suggest that we were not prepared and we went ahead and launched. Yes, we had a launch, and that launch is just part of a rollout program. The devices are out there, the platform is ready, and we are very comfortable as to where we are right now. Thank you.
Thank you. Ladies and gentlemen, do you have any questions for Senator the Honorable Rohan Sinanan?
Minister, just to get some decisive clarification. Was there anything that was outstanding that would have made it difficult to proceed with proclamation in time for Monday that you are only now putting in place? Aside from you're mentioning the devices are there, the platform is there, but was there anything outstanding that was a barrier to proclamation?
Okay, there is nothing that is outstanding that will delay the process. There's nothing that is outstanding. Like any new system, you will have some teething problem. Now, this is a drastic move from where we were before. This puts us on par with any developed country in the world in terms of how we operate our demerit point system. But there's nothing that will stop us from proclaiming the law once we feel comfortable that, you see, we have to give the citizens a fair chance. And like anything else, once we launched on the 22nd of January, only then a lot of people started to pay attention to what was about to happen. We saw no reason why we can just hold the demerit point system for 1 month, allowing people to continue to cooperate, continue to go to the license office, get their information updated. Because you can be charged now under the old act. All right, and I will leave that for the Attorney General to explain more into the law aspect of it. This is where we actually transforming the way we use the road. It's a big jump, and we feel 1 month allowing the population to buy in more into what we're doing, continue to improve their information. We didn't see any harm in doing that. So we had asked the Attorney General to just hold 1 month on the proclamation, while the population is more informed as to the way going forward.
Attorney General?
Yes, thank you so much, and good afternoon to everyone. May I just put this into context? Let's give you a scale. Laws are generated for the peace, order, and good governance of our society. We've taken 40 years of old talk. We've abandoned the idea of a motor vehicle authority. Remember when that was current news for decades? The last government tried to pass a bill for motor vehicle authority. We went to the parliament, we said, look, we'll divide this up and we'll sober Trinidad and Tobago literally into compliance. We started with implementing the speed limit. 6 speed guns changed the culture of driving. People complained, why did you reduce the speed limit? We had to tell them, no sir, we implemented the existing law and then we actually raised the speed limit. To give you why this editorial was so drastically wrong, there are 104,000 cases for motor vehicle and road traffic offences every year. There are over hundreds of thousands of users on the road at any one moment in time. For an editorial to chastise the minister for ensuring that the population is up to speed with the law, one has to question why the editorials, when we implemented the licensing stickers for vehicle inspections, went the opposite way and said more time should have been given. When we implemented the speed gun, they said more time should have been given. I want to compliment the Minister of Works and Transport for not only implementing the law, but for also gauging the population's readiness for this. If I could explain, the matter of proclamation can happen overnight. This country is well aware of that. We saw Section 34 proclaimed overnight. You can proclaim a law at any point in time. The question of the readiness of the citizens of Trinidad and Tobago for proclamation is key in the operation of this law when proclaimed, and that can happen instantaneously. We will have the old law of offences converted to violations. We will have 104,000 cases per year moving into violations. We will have the TT Post, the judiciary, the Trinidad and Tobago Police Service, the payment of online facilities. We'd have the licensing authority all operating in tandem, and they have been in a state of readiness for over 1 year right now. We've test run this system for over 1 year. The last piece of the puzzle, and therefore the tragedy in the editorial, was making sure that people are brought into compliance by knowledge and understanding. So we want to distance ourselves from the editorial. We quite simply want to say, we believe that the law ought to be applied for the benefit of citizens. This is radically new and improved law. It affects our ability to fight crime. There are 146,000 cases in the magistrates' court every year. 104,000 of those cases is motor vehicle and road traffic. 8,500 was marijuana. 26,000 preliminary inquiries. By proclaiming this law and putting it into effect, we effectively, when we do the proclamation of preliminary inquiry abolition, which will happen in a matter of short measure, we will have dropped the caseload from 146,000 cases per year to 8,500 cases per year. 43 magistrates, instead of doing 146,000 cases every year, they'll be doing 8,500 cases. So this is why the minister has been so careful in conjunction with a multi-sectoral committee to operationalize this law. And we really want to tell Trinidad and Tobago, one should not be, how should I say, put off by having clemency and preparation in this position. And it is so sincere a position that the editorial needed to be addressed this afternoon.
Jump up on Monday morning, the day that it's supposed to be implemented, and decide that you've only now gauged the population's readiness enough to say we'll pull it back.
So it wasn't Monday morning.
Well, that was when it was announced, that there was going to be a pullback and a delay on the demerits.
Easy answer.
Does that not undermine the exact compliance?
Okay, so let's put it this way. Trinidad and Tobago, let's accept our country the way it is, right? Isn't it fair to say that the vast majority of citizens are very last-minuted?
Why encourage that?
Hold on. So it's not to encourage it. Unless people know that there's a sanction, they will just approach a laissez-faire thing. We saw it with the motor vehicle stickers. We saw it with the inspection stickers. People only waited until the last minute to go into it. The only example where there were no rush lines was in the demonetization, where the lines were empty on the last few days of December. So having a deadline date and then giving a change of date on the date is exactly the way you encourage Trinidad and Tobago to make sure that they do it. If you tell our population, and Fane, you must know this, if you tell our population, don't worry with the deadline, we'll extend it, nobody will comply. So let's be realistic about Trinidad and Tobago.
In just a different way by popping up on the day it's supposed to be implemented and saying you have an extra month.
I don't think you're that correct in saying that it was announced on the morning. You may need to check that because I don't think that is correct. Now, again, this is a drastic change from what we were accustomed to. This is not a grace period that you can do the wrong and you won't be charged. You will be charged under the old law. What we have actually held back is the demerit points, because what we did not want the population and certain citizens who did not understand it clearly to get up and realize they got 3 violations in 1 day and tomorrow you don't have a driver's permit.
But if this is about road safety, why not just go full speed ahead, considering
It's more than road safety. It's much more than road safety, and by not implementing the point system does not really in any way give the impression that you're not paying close attention to road safety. As a matter of fact, these devices are out there on the road now. The officers have them. When they stop you, you could be charged under the old law. So it is not a right. And the thing about it is that if it took 40 years And the population is, within the last month or so, have decided, look, we are paying a lot of attention to this. And I have seen a significant amount of people come into license office who did not even realize their driver's permit was expired. So what this is bringing is a lot more awareness in the population and compliance, and it's actually helping us to upgrade a lot of the information, which will also be used in crime fighting. So I found it a little bit unfortunate when I saw the editorial, because when I did get the call from the newspaper, they were of the opinion that that did not even go to Parliament as yet. And then I had to draw the difference between the proclamation and the actual debate in the Parliament. This was already debated. But you can't do the proclamation today if you want to use the old law for at least 1 month. Again, to allow the population to be abreast as to, look, this drastic change. This is a drastic change. It took about 40 years to get here.
If a month has passed and we're ready to proclaim and we see the same thing, more people are coming together also now, and could we see another extension?
No, it is going to come in. I mean, at the end of the day, we are happy for the interest being shown by the population. We are happy for people coming to license office and upgrading all their records and things like that. There are a lot of transfers that are taking place that people would have sold vehicles for 5-6 years and never bothered to transfer the vehicles. Now, you can lose points and things for that. You can be charged for that. So this is a system that I want to compliment the citizens for actually paying so much attention to. And if as minister, I have to take a decision to allow 1 month for this to continue, then it's a decision that I'm happy that I took.
So no more extension?
Well, no, there will be no extension. We have put a date now. We have given the devices out. The officers have the devices. And they're dry running. And as I said, within half an hour, on one pilot project, we were able to pick up stolen vehicles and people were charged.
How many vehicles you want to...
Well, I can't give you a figure now. All I can tell you is that there were stolen vehicles picked up. And I know in one instance, somebody was charged within 24 hours. That is how efficient the system is.
Final question to Mr. Senator, please.
Good afternoon, Arbushi from TV6. So I'm referring to your statement on Sunday, right, which it said two different things as it referred to the two different weeks. It said that the merit point system and the new trafficking system, red light camera enforcement system, will be introduced. Those systems will be introduced on March 2nd. However, the proclamation will occur on April 2nd. So to me, my impression was that it was a trial period. However, what you're saying today kind of gives me a feeling it's more like an amnesty. How would you refer to this month?
No, it's not an amnesty. It's just that the demerit point will be in effect by the 2nd of April. It's not an amnesty because you're going to be charged under the old.
Just to clarify, there's nothing inconsistent in the minister's statement. He said that the law, let's go through it. The law was passed, it was assented to. There's a proclamation clause. The date was given to the population in January that we're aiming for March 2nd. What the minister said is that it would be implemented, and he did. He put people out on the road with the devices. They're dry running. They're stopping people. We've had charges under the old laws for stolen vehicles, etc. What he said, yes, what he said is using the new tools, applying the old law. What the minister said that you just read out there was that the proclamation of the full effect of the law will be put a month later. But the minister specifically just used the term dry run, meaning that people will see the officers out and about as they are. People are seeing the application of the tools, etc. They're now aware that an officer has a live device in hand, can talk to a licensing division immediately. And you see, that immediacy helps us with crime. Remember, a stolen vehicle, a getaway car, a murder suspect, all of these things, roadblocks become now active crime scene investigation points. This is taking Trinidad and Tobago to what you see on the movies. You're seeing real-time identification, because the minister hasn't told you, or perhaps emphasized enough, every driver's license has been digitized. All the information, all motor vehicle information has been digitized. All of it is live. TTPS, judiciary, and the ministry. So this is a massive crime-fighting tool. When you have 1 million driver's license, million cars on the road, if not more, you've got hundreds of thousands of drivers on the road. The sheer volume has to be appreciated because you don't want to crash the citizens of Trinidad and Tobago. You want them to be aware, to have seen the opportunity to be prepared, so you can turn back and say, hey, listen, you were warned, you saw the dry running, you understand the consequences, it's too late to cry. And that happens on April 2nd.
Thank you.
Let me just reiterate what the AG said. If they stop you and they warn you, that is in the record. Going forward, they can pull up and say, but on this date you were warned. You were warned already. So this period between now and the 2nd of April, the system is actually working. What is not being applied is your demerit points at this point in time. That is what it is. Because we're giving you an extra month to familiarize yourself with the entire system. And as I said before, if we're making this quantum leap, it is important that the population understands where we are heading.
System, you would have, as you said, all driver's license already digitized. Would you already have account on people's infringements as it stands?
Yes. They're all digitized, entire records. Listen, the reason why laws seem to not have consequences in Trinidad is that nobody was applying technology, people and processes. The Minister of Works and Transport hired an entire division of enforcement. He hired an entire division to digitize. He hired an entire division to update positions. At the same time, the judiciary was doing the same thing. All cases identified, etc. We're going to be bringing some legislative tweaks to treat with the backlog. There are about 60 to 80,000 cases in backlog. We're going to treat with the backlog at the same time we deal with the go forward. This means that there's a consequence to law. Understand what this Minister of Works and Transport has done. He's taken 40 years of old talk and operationalized it. Hired people, created divisions, brought in the technology, put it on the road, passed the laws, digitized the information. All of it is crime fighting. You must agree that removing 104,000 cases from 146,000 cases is an epic success in this country because people are crying for justice. You get to the court, the magistrate is not available to do your case because of the sheer volume of cases. So one of the ways is to remove matters in terms of volume. And no one has ever approached crime fighting that way. This Motor Vehicle and Road Traffic Amendment is a material crime fighting tool. And I should tell you that we have in Parliament right now, and we're going to be debating in a matter of a week or so, the further amendments to the Motor Vehicle and Road Traffic Act, which are the introduction of spot speed, the introduction of RF tag IDs, the tintometer positioning, in other words then removing the capricious nature for being charged as to whether your tint is too light or too dark, and in the RF tag ID, all number plates in Trinidad and Tobago will be changed out and a tag will go into it so that on the road the police will know where you have passed. And again, that is a massive crime fighting technique, and the minister is just reminding disability parking is a feature of that law because our disabled population, our differently abled population, they are at a material disadvantage in not having access to convenience. So these are on deck, they're in Parliament. The technology for that is already here, and we'll be implementing this. This is 40 years of old talk by everyone else, operationalized.
Thank you very much. Mr. Attorney General, could you tell us about the legal fee kickback case?
Good afternoon again, ladies and gentlemen. I've come to speak to you on a few matters, two in particular, and then to receive your questions on certain other matters that have been put to me. The two matters that I wish to address this afternoon are, first of all, the matter of the plea bargaining arrangement, which led to conviction and sentencing of Mr. Vincent Nelson QC. I propose to speak about that very carefully, as I don't want to cause any pretrial prejudice to another series of matters that are ongoing. And then the second matter that I wish to speak to you on is perhaps one of the most important issues which has not been canvassed adequately in my view, and that is the Interception of Communication Act, which has been passed in the Senate and which is of massive importance to the people of Trinidad and Tobago. The third item that I perhaps will mention is the Financial Action Task Force position, as it relates also to the Global Forum material which we just passed in the House yesterday. Permit me to address item number 1, which is the Vincent Nelson matter. Trinidad and Tobago often cries out for justice. Trinidad and Tobago constantly has a criticism that justice doesn't seem to work in an equal way. People often complain about the big fish. One newspaper alone, by way of editorial, and this is the Newsday, actually captured the significance of the Nelson matter. I want to remind you that Mr. Vincent Nelson came before the courts of Trinidad and Tobago on 3 charges. The 3 charges against him were conspiring to commit money laundering, misbehavior in public office, and conspiracy to commit an act of corruption. Mr. Nelson came forward as a whistleblower for Trinidad and Tobago. Mr. Nelson entered into a plea agreement via a plea discussion with the Director of Public Prosecutions. Mr. Nelson appeared before the courts of Trinidad and Tobago and admitted to his guilt. Mr. Nelson was referred to Mr. Justice Malcolm Holdip, a High Court judge, for sentencing, and Mr. Nelson was in fact sentenced, and he was exposed to the payment of over $2.25 million in fines, in an arrangement where he will suffer hard labor for 2 years if he's in default of the fines. Mr. Nelson's matter therefore touches a lot of the legislative and operational work that the country has been begging for. And it is important for us to underscore the change in Trinidad and Tobago's criminal justice system. In the Nelson case, we have addressed, as I just pointed out to you in the tags, whistleblowing. As you know, the opposition refused to support whistleblowing legislation. In this case, that is a whistleblower at work. Number 2, we introduced in our reform of the criminal justice system and in the fight against crime very important amendments to the plea bargaining, plea negotiation legislation. In the plea discussion arrangements which existed prior, because there was always plea bargaining law in Trinidad and Tobago, at least since the year 2000. In the period 2000 to 2019, at best, a couple matters came before the courts. In those matters, Trinidad and Tobago has been witnessing that trials usually take years to be conducted. You're well aware the Piarco Airport matter is going on its 20th year. You're well aware of many other matters, 18 years, 15 years, etc. We also passed a criminal division bill. And in the criminal division bill, we allowed for the High Court judges to be very specially appointed by the judicial systems so that money laundering matters were given priority. Devant Maraj, who is the chief spokesman for the UNC, as you're all well aware, when the Financial Action Task Force stepped out of its crease and hailed Trinidad and Tobago for being the only country in the world at this plenary to come off the grey list, Devant Maraj, as the true UNC patriot that he is, put into the FATF a reply saying nobody in Trinidad and Tobago has been convicted for money laundering. In other words, inviting the world to undo the success that Trinidad and Tobago had done. Not only is it untrue that we have had many matters of conviction for money laundering, but the Vincent Nelson matter involved a conviction and sentencing for money laundering in what has been described as the largest case of money laundering and conspiracy to commit fraud in Trinidad and Tobago to be completed. Let me repeat that. The largest case. This is not a matter of an average arrangement. This is a Queen's Counsel from an English jurisdiction subjecting himself to whistleblowing testimony. It is therefore important for us to underscore that the criminal justice system has definitely been successful in reform. Not only was a matter completed in a matter of a year, plea discussion, plea agreement, conviction, and sentencing. And that is a landmark decision for this country. It is a landmark decision in the Commonwealth. I therefore appreciate that Carnival may have distracted from some of the news cycling. I noticed that we are very accustomed for news stories of scandal carrying front page, but successes hardly ever cover front page. And as Attorney General, it is important for me to address this particular matter in the context of telling Trinidad and Tobago, your criminal justice system is working. I want to be very specific that I make no commentary at all on the Ramlogan-Ramdeen case. Those gentlemen are alleged to have committed certain acts. They are innocent until proven guilty. The due process will go to work in that matter. I am not speaking about that matter, notwithstanding its size and importance to this country. But the Nelson matter, which has been subjected to the DPP's consideration and the court's consideration, is a very successful matter for the country to take note of. For all people who are crying for big fish to have consequences, in my recollection, I don't recall ever a charge, a fine of $2.25 million having been levied, certainly not for a money laundering matter. And money laundering is the subject of taking the profit out of crime. It also underscores the need for the population to continue to agitate for whistleblowing laws and to call upon the opposition to stop resisting whistleblowing legislation. Whistleblowing legislation is critical to crime fighting, and the opposition has consistently refused to support whistleblowing testimony because of the 3/5 qualification in certain parts of that law. The second matter that I wish to address is the matter of the Interception of Communications Act. Ladies and gentlemen, that amendment to the Interception of Communications Act is one of the most important amendments to the laws of Trinidad and Tobago. Number one, it introduces constitutional safeguards that are absent in the existing law. It is arguable that the existing law, passed in December 2010, is open to constitutional challenge on the ground that the admissibility of evidence is not a matter for the judge. Let me repeat that. Because the Interception of Communication Act 2010 says that evidence is automatically admitted in certain circumstances, it is open to argument that you are taking away the court's duty and jurisdiction to consider the fairness of a trial in admitting evidence. So the first thing that we have done in that law is to make the law constitutional or more constitutional. The second thing that we have done in that law is to improve the protection to the members of Trinidad and Tobago society, and in particular the media corps. I've noticed a ridiculous submission coming from Wade Mark, and his submission is that this bill allows for the first time a magistrate to allow for stored data to be taken. What is stored data? Think of your phone, think of your computer, think of your WhatsApp messages. That submission from Senator Mark is completely and grossly untrue. The existing laws of Trinidad and Tobago since 1917, in the case of the Preliminary Inquiries Legislation, Chapter 1201, and since the Proceeds of Crime Act in 2009, the existing laws, Section 5 of the Preliminary Inquiries Act, Sections 32 and 33 of the Proceeds of Crime Act, and also the Administration of Justice Preliminary Inquiries Indictable Proceedings Act, which was passed in 2012, those three laws allow for stored data on telephones, for instance, computers, for instance, to be obtained by virtue of a warrant, a magistrate's warrant. That law has existed without protection. In this bill, we have specifically made sure that the warrants for the production of media information, for example, because I've heard it addressed in the context of the media, or normal citizens, we are mandating that confidentiality must be preserved. We are mandating that assistance must be of the type in the Interception of Communication Act, which is at a higher standard. And we are creating an offense for the police up to the rank of Commissioner of Police to share that information in breach of confidence. We are therefore adding a very important protection for the media and citizens of Trinidad and Tobago, which does not exist in the Preliminary Inquiries Act, the Proceeds of Crime Act, or the Administration of Justice Indictable Proceedings Act. That does not exist. The third thing that we are doing, very critically, we are all well aware that prisons have telephones in them. Notwithstanding the amendments to the law that we have made in the Prisons Act to criminalize very heavily prohibited articles, including telephones, miraculously, telephones end up there. Notwithstanding the hard work of the prisons officers associations, etc. What we have done in this particular law is to say, if you are in a prison and you are not in the room or in the place or in the facility where you're talking to your lawyer, that we will have the ability to record your conversations by way of bugging. You bug the prisons so that a prison is a prison is a prison. And quite shockingly, the UNC says they need to protect the prisoners' rights. Quite shockingly, Senator Mark says we cannot interfere with prisoners' rights. We are aware from the National Security Council level that there have been criminal acts conducted and called for from inside of the prisons. The UNC says they need to protect that. We say that if that evidence of bugging or interception is under the regime of non-warranting, in other words then, right now Trinidad and Tobago, Section 6.2b of the Interception of Communication Act, passed in 2010, allows everybody to be intercepted for national security purposes, media included. The media intrusion happened in 2010, unless you don't remember. 2010 December is when the ability to intercept the media happened. We have said in this bill, if you want a court to consider any evidence, the court must give permission, and we've added very careful safeguards to say what the court must ensure. Fairness of trial. You were not entrapped. It is not an undue position. So we are adding constitutional protection to the media in particular and the average citizen in particular, which never existed in our laws. Not in the Proceeds of Crime Act, not in the Preliminary Inquiries Act, not in the Administration of Justice Indictable Proceedings Act, and not in the Interception of Communication Act. I therefore urge you to fact check me. Go and look at Sections 5 of the PI Act and the Administration of Justice Act. They're both Section 5. Go and look at Sections 32 and 33 of the Indictable Proceeds of Crime Act. Go and look at the Interception of Communication Act, Section 17 as it exists right now. Section 17 and Section 19, and you will see everything that I am telling you is completely true. This piece of law has the ability not only to save challenges that could come to upset every communication intercepted under the legislation. We want to protect, as a matter of general principle, all interceptions that have occurred over the last 10 years. We want to protect all trials that may be in existence. We want to add safeguards to the law, and I need to underscore the importance of this in the fight against crime, and I ask you to check what the UNC has said, the opposition has said, and you will see that everything that I am telling you is completely true. The last point that I wish to address with you is the Financial Action Task Force. Trinidad and Tobago in January 2015, we underwent the 4th round mutual evaluation and we failed dramatically. We were not ready. we were put onto a grey list, we were put into enhanced follow-up at CFATF, and we were put into something called the International Cooperation Review Group, grey list. Many countries stopped doing business with us. We were delisted, we were debanked, etc. As Attorney General, I had to pilot 23 individual pieces of law. I had to engage in the reconstruction of operational procedures. This was very closely aligned to our fight against crime and white-collar crime in any event. And Trinidad and Tobago, last month in Paris, we received international praise for the work that we have done. And we were the only country in the world at that plenary to come off the grey list. That feeds directly into the Global Forum and the European Council position, where we are blacklisted because of A, the FATF position, which has now disappeared, and B, because we failed to pass the Global Forum reforms signed up by Mrs. Prasad-Bissessar in 2011, nothing done until 2015, and we were blacklisted. Yesterday, we managed to pass the Global Forum package when we passed 3 pieces of law. In one piece of law, they all went to a Joint Select Committee. The opposition refused to support the Joint Select Committee's work. In one of the bills, we changed a comma. Sorry, it was a semicolon. In another bill, we amended Section 117A of the Income Tax Act. And in another one, we harmonized with what we did in FATCA. Those things were ready 3 years ago. 3 years of torture by the opposition, of refusal to pass the laws, ended yesterday by one small amendment which we made, which we warned the leader of the opposition we don't necessarily have the consent of the Global Forum to do. We're going to wait to the Global Forum to tell us whether they will accept it, and Mrs. Prasad-Bissessar accepted that position. So even though it is extremely late, even though it was a torture in exercise, we have managed to pass that law in the House. It's now on its way to the Senate. Those are the 3 areas that I wished to address with you, and I certainly open myself up to any questions that you may have.
Mr. AG, on the Interception of Communications Bill now, during the debate it received some criticism in Parliament for the fact that there's no timeline on past data. One senator was saying that they could go as far as back as BB BlackBerry and use that data against any matter for that. Sure. He was suggesting it was not just for a criminal matter, but for any matter, including a civil matter. How would you address those?
Sure. Well, that was the nonsensical, ill-prepared preparation by Senator Sturge that you're referring to. Senator Sturge made the submission that this law allows for stored data to be intercepted. Senator Sturge came unprepared. I just told you the stored data since the Preliminary Inquiries Act, the Proceeds of Crime Act, and the Administration of Justice Indictable Proceedings Act, Section 5, Sections 32, Sections 33, and Section 5 of those 3 specific laws, always allowed for stored data to be taken. So that was always the case. And it is so ridiculous a submission by Senator Sturge. Senator Sturge forgets that there is no statutory period of limitation for crimes. You can have committed a crime 20 years ago. You're still exposed to the crime. So that submission is a ridiculous submission. It is untrue. It is misleading. It is malicious.
Data was always accessible. I guess the question would be who's protecting that? Who's protecting the data? And even when it comes to the bugging of prisons, of the prisons, prisoners, yes, you should be entitled to go through that and ensure that there's no criminal activity taking place there. But what about conversations that prisoners may have with their spouses, with their children? Who's protecting that data?
Sure. So those are 2 questions, and they're very good questions. First of all, who's protecting the stored data? Prior to this bill, nobody, in the real strict sense, other than the court order, the warrant. We have introduced protection for the first time. We looked at the Preliminary Inquiries Act, where you could get the stored data. We looked at the the Proceeds of Crime Act, where you could get the stored data. We looked at the Administration of Justice Indictable Proceedings Act, where you could get the stored data. And we noticed there were no protections. So we have said, put a protection, put a confidentiality, limit disclosure And if you breach the confidence, you have an offense, even up to commissioner of police level. So to answer your question, we are protecting the data now in a very substantial way for the first time. And that's something that obviously the UNC is afraid to see. With respect to the prisoners now, many jurisdictions, Canada, the United Kingdom, New Zealand, Australia, the United States, and European countries, all allow for prisoner intercepts and recordings. What must be protected is the right of the prisoner in particular to legal professional privilege, because we must protect against the right against self-incrimination in that arena. There is no self-incrimination in the strict sense where two accomplices are talking to each other and confess to the crime. There are a lot of case law on that point, and the European Court of Human Rights, in reflecting upon Article 8 of the European Convention, which is very similar to our enshrined rights, has also upheld this position. So the point is, we have roughly about 3,000 inmates, at maximum 4,000, because you know people come in and come out depending upon remand. Those 4,000 people, those 3,000 people cannot be allowed to run criminal empires. We are counting the murder toll by the day, aren't we? Every newspaper has a tag, how many murders by the day. We are in a situation where the opposition says, we're not supporting bail amendments under Passad Bissessar. If you had a firearm in your possession, no bail. No bail for you for 120 days. Under the PNM, we come and say, if you have an automatic firearm, an AR-15, a weapon of war, a grenade, we're saying, go and tell the judge why you should not get bail, or why you should get bail. We're not even saying no 120 days. We're saying, go and tell the judge on a reversal of burden basis why you should get bail. And the opposition won't support that. Yet they come by the day and tell you, check the murder toll. They refuse to support the Interception of Communication Act. They refuse to support the bail amendments. They refuse to support whistleblowing protection. They refuse to support the amendments to the Income Tax Act. They refuse to support the miscellaneous provisions. They refuse to support the foreign tax, the foreign accounts legislation. You remember what happened with FATCA? They had to go kicking and screaming to support. Global Forum, they had to go kicking and screaming to support. Anything that involves foreign accounts seems to be a problem for the UNC. Anything that involves bettering the situation in crime detection and conviction is a problem for the opposition, from my humble perspective, respectfully said. So I am asking the Fourth Estate, check the facts that I am giving you and notice the truth in what is being resonated.
I'm a layman, right? And when we do these amendments, Bill, it's difficult for me to take, insert, delete, and put that into the act.
I solved that. I issued and circulated marked up versions of the bill. I'm the first Attorney General in the history of Trinidad and Tobago to engage in a practice of circulating the law as amended. I don't hide behind insert this and delete comma that. I don't do that. I circulate for the whole world what the law is proposed to look like in its final form. That's on the Parliament's position. Every senator, every member gets that copy, including the opposition. When I was in the opposition, I'd have to sit down painstakingly and write it out into the bill because they hid behind the amendments. I don't do that.
I don't know what version I have, but I'm just referring to Clause 11. If you could clarify it for me.
Of which bill?
The Interception of Communications.
Clause 11, which amends Section
11.
Right.
It says here that by deleting and inserting, it allows a judge to issue a warrant that's under urgent circumstances to authorize a person named in the warrant to intercept communications and disclose it. So, I mean, as a layman, a judge could come to me and tell me to contact one of my contacts and get information from them.
Okay, so understood. So Section 11 is the existing law since 2010. That is where you can go and obtain a warrant for interception on an urgent basis, and you have 96 hours to go and file the papers. All that did was to tighten some of the language. That law existed since 2010. It's been in effect for 10 years. So there's nothing new about that. For 10 years, we've had the ability to do emergency warrants.
And urgent circumstances would be like, for instance,
That was defined in the law in 2010. Same thing we've been doing for 10 years. Nothing new. What's new in this law? Constitutional protection. What's new in this law? Constitutional protection and confidentiality for warranted information under other laws that didn't exist. There was a big loophole in the law. What's new in this law? Make a prison, a prison, a prison, a prison. You're a prisoner, don't use the phone. If you're using the phone, we want to use the evidence of you on the phone to lock you up more or to treat with you. I can see nothing wrong with that. The Privy Council, the European Court of Human Rights, the United States Supreme Court, the Court of Appeal, the Supreme Courts in Australia, in New Zealand, everybody has it except the UNC.
Mr. Attorney General, if I could just raise a couple other matters.
Sure.
This issue of the counterfeit polymers, we have a couple of agencies, the Ministry of Finance, the TTPS, saying that they have no official reports about counterfeits, but we've actually seen one as per the subject of one of our stories this week.
You physically saw one?
Yes.
Right.
We physically have.
Did you report it? Yes or no?
We were not the recipient of it.
My
It was
point
handed
is,
over to
you
us.
did not report it, right?
That was left up to the person who received it.
Right,
as
so you've
part
just
of the
proved
list.
your own first question, but let's go on.
1 second. There is a question about whether or not you, through your ministry, can do anything about it. 1, and 2, what would you say to people who are seeing this and then not reporting it?
Sure. I mean, thank you for allowing me to tease you as I normally do. I, of course, mean nothing disrespectful by that. But the reason why I asked you that question as sharply as I did is that sitting here as Attorney General of the Republic of Trinidad and Tobago, I can only act upon official matters. So in other words, then I can't speculate about certain things, right? There is a huge issue of fake news in this country, as you're well aware. You saw what Devant Maraj put out about coronavirus in schools. I mean, many members of the media sent that to me and asked me, what are you going to do about that? Enough of the fake news. I mean, that is incredible. This issue of the video that's circulating with the person cautioning about the counterfeit, etc. Counterfeiting of notes is nothing new. There'll always be counterfeiters from time immemorial. One should always be careful to inspect whatever you have. It was never said by the central bank or the Minister of Finance that the polymer note was incapable of people not trying a fast one. What the Minister of Finance and the central bank and the producers of the note said is that there are more security features which you can rely upon to avoid the risk of counterfeiting. What I encourage people to do is that if you actually have counterfeit currency in your possession, report it so that the law enforcement agencies can go to work. So for example, Fane, in your circumstance where you say that you received counterfeit money or saw counterfeit money, you can report that, you can take that to the central bank. All of you are well aware, you see many people in other jurisdictions have the particular pens or features to check counterfeits, and you see them literally checking bills. I've seen it in other countries when I travel, etc., where people check bills. You still have a positive obligation to be on the lookout and to check for yourself whether things are counterfeit or not. You must expect smartmanism and counterfeiting to always be a feature of our society. What the government can do is to make it harder and harder for that to happen by improving security features.
The other matter I wanted to ask about was the petition that was given to Whitehall by some of the advocacy groups working with domestic violence victims. And one of the things that the petition called for was the immediate amendment to the Domestic Violence Act.
Yeah.
Have you any timeline?
Sure, absolutely. In fact, when Roberta Clark, who was one of the 3 people that handed over that petition, called me, we agreed that we would exchange. I've drafted the amendments to the Domestic Violence Act already, long time, handed it to them. I'm just awaiting the public comment on it in a matter of a week or 2, and we head to Parliament immediately. I have drafted significant reforms to the Domestic Violence Act. I understand Mrs. Lynette Seabrand-Sweet this morning was complimenting the Office of the Attorney General for doing that. We have also been sitting at the table together, drafting the amendments to deal with sexual harassment, and that's nearly finished as well. I'm pleased to tell you that today the Cabinet approved the laying of the Electronic Monitoring Amendment Act and the regulations, and contained in that Electronic Monitoring Act is a very important feature for the use of corresponding bracelets. if you are a victim of domestic violence and you have a protection order issued, the person against whom the order is issued will have a bracelet, and you, the victim, the person who has the order, you'll have a corresponding unit. Proximity alert goes off, so you know if the person is in proximity, but more particularly, the electronic monitoring unit and the police, they get the alert as well. That is a feature of that particular piece of law. It's a nuclear improvement to the arrangements. We've been tracking this issue of femicide and domestic violence very carefully. As Attorney General, together with my colleague Minister Webster Roy and my colleague Minister Young, we have taken this issue very seriously, and we brought forward some very important amendments, which I expect in a matter of weeks to take to the Parliament.
Besides the electronic monitoring corresponding bracelets, what some of the recommendations are that are going into the amendments?
I'll do two things. One, I'll send you a copy of the bill so you can have a better sight of it, because I welcome comments from the general public as well. So I'll undertake to put it up at the website of the Ministry of the Attorney General immediately. The other aspects of improvement include broadening the persons who can apply for the domestic violence protection. You see this concept of household? Household is a very difficult concept because it's very narrowly constrained in law. So we've gone to improve the dynamic of household, improve the methods available to the court to provide relief. We've also gone for something called emergency applications, where overnight when a court is not sitting, on the weekend when a court is not sitting, that you can get an urgent protection order so that you have enforcement. That ties in with very critical reforms that we've done at the TTPS, and I commend Commissioner Griffith for establishing and broadening, Minister Young for pushing and pioneering the Child Protection Unit and the Domestic Violence Unit. Minister Young has been pushing that instance forward, and together on the operational side of the TTPS, on the operational side of the Children's Authority, on the operational side, we marry it in with emergency applications, etc. So there's some very powerful amendments that we have brought forward.
Will any of the amendments penalize police officers who receive reports at the station and don't follow up?
That's a very interesting point. So I had not considered that in that piece of law, but it may very well be useful to do a consequential amendment to the Police Service Act to treat with that particular aspect. There is existing law, obviously, under the police service regulations that treat with that, and failure to handle certain matters. And as you know, we did a miscellaneous provisions bill recently where we did amendments to the whole of law enforcement services for failing to do certain things. So that's a very interesting point that you brought forward. I'm taking a note of it. And before we get to Parliament, I'll definitely see if that can be a captured aspect together with the consultation.
Staying on the same vein, I have two questions regarding the sex offenders registry. I'd like to know the status of it because it's not online as yet. There was an individual, the spouse of Nicki Minaj, Mr. Petty, who would have entered our jurisdiction. He's a known and public sex offender. Of course, within the Act, a sex offender from another jurisdiction is required to register upon entering our country. I'd like to find out if that process is in place, if there are specific forms, if on the immigration form someone is required to declare such.
Sure. So
My second question.
That was two questions. You asked about the status and then you asked about Petty. So you've got a third question.
The status question is in relation to the Act itself, which I would have messaged you about. There seemed to be a contradiction because it said that a magistrate must order someone's name to be added to the online sex offenders registry. However, later on in the Act it says 60 days. Yes, a judge. It says 60 days from the proclamation of the Act, which has already passed. Someone who has completed their sentence must visit the nearest police station to register. So I'm wondering, does a magistrate have to order it, or do you expect a sex offender who's completed his sentencing to visit a police station and just register? You expect them to comply?
Okay, the first thing I invite you to do is to read the Act. It's been proclaimed. It's the law of the Republic of Trinidad and Tobago. It's not a magistrate, it's a judge. In the year 2000, Attorney General Ramesh Lawrence Maharaj passed the Sex Offenders passed the amendments to the Sexual Offences Act and introduced Part 3 of that Act. In Part 3 of that Act, he created the concept of registered sex offenders, right? In the period 2000 to 2019, we had 1,600 plus convictions for sexual offences. In the period 2000 to 2019, we had nobody put on the sex offenders registry. Why? The 2000 law said, upon conviction, go and report to a police station that you're a sex offender. Well, how are you getting convicted, sent to jail, you're being taken to jail in that direction, and you're supposed to break loose and go to the police station and register yourself as a sex offender? It was nonsensical. It was nonetheless the law. It's probably why we had no sex offenders. When we passed the amendments, we did, as you recall, a special select committee, and we had a lot of input from the NGOs and interest groups concerned about this matter, which we were very grateful for. The government's initial position was the minute you're convicted, we'll put your name on the register. The groups raised certain concerns, which we agreed to. They said, look, let a judge and only a judge tell you that you are going to go on the register. Why? Let's suppose it was a case of incest, and Trinidad, as a small society, knows X was guilty of incest in respect of his or her daughter, and you now know the whole situation. There's a lot of merit in that position, right? So what the law currently provides is a judge will say, when you go on the register, you're convicted of sexual offense. We deal with all of the areas of conviction. You get sentenced and you go to jail. You get a reprimand and discharge and you never go to jail. We treat with those. We say at that point in time, you must have a psychiatric assessment of the person, and then the court will consider putting you on the register. We say in the legislation that you can ask the court to consider why you should not go on the register. Let's use the incest example, for instance. A court will then say that you go on the register, order that the Commissioner of Police put you on the register, and then you are published on that basis, and then there's certain exceptions if you're in jail, your reporting requirements, etc. So the law is very robust. Yesterday, as a matter of fact, I moved and passed a motion to amend the schedule to the Sexual Offences Act to create a broader category of registrable offences. I can tell you that right now, we have, because the law couldn't go retroactive, it must be prospective, right? We're now filling that pot. The register is created, the web base is existing. We're waiting on judges to now fill that pot. I can tell you in a matter of weeks, that pot will begin to feel a sense of relief because it's going to be filled. So we had to be careful on convictions in the period 2000 to 2019. As people are being released from prison, at that point, we provide 4 weeks prior to release, number of weeks prior to release. The prisons must inform the police that you're going to be released. The information must be transmitted. The court must consider if you're going on. So we have that whole system designed. And I can assure you that that law is not only proclaimed, but the pot will start filling very shortly.
Who would have been convicted from since 2000 but would have completed their sentencing, so they no
The equality of treatment became a constitutional issue. And knowing this opposition, who don't support anything that is a 3/5 majority bill, we went with a simple majority bill because you could have had a constitutional challenge to people who were convicted and released and went on their merry way when the existing law wasn't operationalized. So it was a very messy situation. What we know is that we proclaim the law. Certainly there'll be a whole cohort of people in the period 2000 to 2019 that a court will consider, and I can tell you I'm aware of matters before the court right now. That's why I'm speaking so confidently about the pot beginning to feel a sense of relief. You asked a question about the Nicki Minaj situation, her husband, and that's the second point. The law requires that registered sex offenders report. The situation is easily found as we go to people that require visas. When visa applications are filled, you know if people have offenses, etc., and it's disclosed. We don't have a visa arrangement with the United States of America. And I can tell you that right now we are working on the removal of customs and immigration forms and the use of harmonized forms. So as we get advanced passenger information systems coming into effect, we'll know who's a sex offender or not. One of the things that we wanted as a government in the sex offenders law registry, we wanted to put a stamp on your passport if you're a convicted sex offender so that immigration would know automatically. Canada does it, but the interest groups didn't want it for Trinidad and Tobago. The government had to comply with that. Otherwise, we would not have gotten the kind of support that we wanted, right? So, short measure, at least we've operationalized the law. It was in existence since the year 2000. It was unworkable, and I'm confident that it is going to work right now. Harmonize that with domestic violence, with sexual harassment, with sexual offenses, with a child protection unit, with the improvements to the Court of Appeal and High Court and Magistracy. You must remember, this government passed the Family and Children Division Act. We amended 19 laws on the first occasion and another 23 in the miscellaneous provisions. And we opened family courts and children courts. We have 25 new courtrooms to treat with that. That never happened before. That has never happened before. So we have taken this issue of child protection very, very seriously. But we've not only passed legislation, we've opened courts. And we have the mechanisms in place. That's the difference between us and the rest of the old talkers.
Mr. AG, according to the Act, someone who has committed a sexual offense, when they enter TNT, they're supposed to notify authorities. They're supposed to visit a police station, if I'm not mistaken, and declare that.
Yeah. So now causing the compliance to that by getting the forms in place is another process as well. You may notice there are kiosks at the airport that are not yet opened. Those kiosks will give us the advanced passenger information systems where we'll know all of that. But you see, you can't get everything in one shot. There's a process of operationalizing, and for far too long, we've waited for the perfect product before we start. The government has said, start, create a court, create a law, create the register, operationalize, fill the pot. We are well on our way to getting to a best-in-case scenario, and we're working our way through it.
With all due respect, Mr. AG, a registered sex offender in another jurisdiction would have entered a children's home.
I'm trying to tell you for the umpteenth time that we don't have the advanced information by way of visa information from the United States of America. And until we can compel that information at the airport, we don't have it. So you seem to know that the man was a registered sex offender. I don't know that. The immigration didn't know that. There's no mechanism to enforce that yet, because we have bilateral risks with the United States of America, etc. So I'm trying to tell you it's not that easy, but we will work our way towards that. If the public is aware of something, well, then we can treat with that. But we don't have an immediate perfect solution right now. What we are is in a materially advantageous position than we were before. You must admit that in the period 20,000 to 2019, with 1,600 convictions, to have nobody on the register was unacceptable. At least we finally have a register. We're headed in the right direction.
We have a question from Liz.
If I could just get a couple quick updates on some projects, the cross-crossing interchange and the walkover at the waterfront in terms of their status.
Cross-crossing.
Yeah.
San Fernando cross-crossing.
Sorry, the bridge. Yes.
Because the interchange is up.
Sorry.
I got excited as the MP for San Fernando West that you were batting a project that doesn't exist.
Yeah, well, the bridge is almost completed, and the deck and everything was cast, and we're hoping to have a full handover, I would say, within the next month or so. Yeah, and just to give a plug for the AG, very soon we will be starting the San Fernando waterfront project with the road upgrade. Reggie, and we'll be happy about that.
Thrilled.
And the walkover at the waterfront, we did have some delays that we were not happy about. However, there was some challenges with the contractor getting in the steel that was required.
That's been solved.
And that have been solved. The steel, I understand, came into the country today, because I think I just saw the update on it. So we're hoping to have that completed in time for the AG's courts that will be sometime in
Permit me to
April.
enter. You know the massive importance of that bridge is, right? Through a public arrangement, Furnace Smith built 1,000 car parks on the corner. We are putting the entire civil courts at the waterfront. And that walkway, you'll notice the concrete structures are built on either side. All that has to happen is for the steel to be fitted on the top. The steel has arrived. It had to be special ordered from China, I believe it was. And that will be fabricated in final form and put in. We're aiming to open the new civil courts in the month of April so that we can get 125 new courtrooms in this country, adding in the children and family courts. Again, no government in the history of Trinidad and Tobago has been able to open 125 courtrooms like that. And that does not include the San Fernando Magistrates Court, which is a commencement of construction, the San Fernando Criminal Division, which is, you'll see where we're demolishing the Magistrates Court at the Promenade. It does not include the Rio Claro Court, the Penal Court, the Arima Court, and the Remand Yard Golden Grove Courts, all of which are happening. So effectively, we will be massively improving judicial accommodation by hundreds and hundreds of courtrooms. And all of these projects are on green light fast run.
So you see, you got two answers for that one question. You could about the walkover and the courts. So again, we should have a full handover in April on the walkover, and the bridge as well will have a full handover on or before April.
I just want to say that's the common sense of the Prime Minister at work. Fix the Red House, make sure it doesn't fall down, move the Parliament out of the waterfront, use the waterfront to create courts and expand the courts. Yesterday we raised judicial age from 65 to 70. That's a big, 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 big win for Trinidad and Tobago. We get to keep judicial talent because we moved the number of High Court judges from 36 to 64. And we moved the Court of Appeal from 12 to 15. Whilst we're reducing caseload, quickening processes, adding hundreds of courts, hiring 500-600 people to back-end the arrangement, creating divisions of court. Folks, you've never seen a plan like that in operation. This is epic. I'm sure you agree with that, Fian Richards.
I love your use of the young people's too.
Well, I'm infected by my teenage children.
Okay, if we have no more questions, thank you very much.
Thank you.
That was live coverage of the weekly post-cabinet media briefing on TTT Talk City 91.1 FM and on TTT Live Online on Facebook. Remember, we'll have more on matters coming out of today's briefing in our major newscast. I'm Mahalia Joseph Wharton. Have a good afternoon.